Hello. It's good to have you again for our second webinar. I'm trying to put my camera on. Unfortunately, I can't manage to have it. But I should be able to fix that soon. Yeah. I'm trying to let you see me. I'm afraid this will not work. Anyway, I will share with you now the presentation, the short presentation that I wanted to give you. This is about the FRAND undertaking, which is often seen as a very short and very basic declaration, but which is in fact which has very far-reaching consequences. Let me show it to you. Now, so the ETSI FRAND undertaking is at the core of most legal disputes in the FRAND or SEP field. We know that it is at the core of all FRAND licenses. We know that it determines the rights and obligations of both licensors and implementers. But too often, the real consequences are not properly assessed. So we will see today what is a FRAND undertaking under applicable law. There has been many recent developments, including one no later than yesterday in a decision issued by the Paris court. And we'll see what consequences this undertaking has on the market players, in both licensors and implementers. And we will also see what tools both licensors and implementers can find on FrandAvenue to help them complying with their obligations. So let's first have a look at what is a FRAND undertaking. Basically, when we are talking about a FRAND undertaking, we're talking about the ETSI IPR policy undertaking. I suppose all of you know what is ETSI, the European Telecommunications Standards Institute. This is SSO, or standard setting organization, based in France, in the south of France, and which has been established at the end of the 80s. For more than 30 years now, almost 40 years, this institution has developed standards, as we all know, 2G, GSM, 3G, UMTS, 4G, LTE, 5G today, and it's the 6G technical specifications are currently in discussions. And to cope with the challenges that intellectual property rights could cause to this standardization system, ETSI has adopted an intellectual property rights policy, which includes this famous or infamous, depending upon who sees it, Article 6, which includes this FRAND undertaking. Let me show you what is how a FRAND undertaking look like. This is basically, I need to share my screen. So here you can see an example of a FRAND undertaking. In this example, this is, I'm not sure you can see it clearly, this is a declaration filed by, I think this is Qualcomm here, back in 2019, which contains a declaration and annexes. And in the annexes to this declaration, you can have, so that's more legible here, you can see first this famous statement, which says, in accordance with clause 6.1 of the HCIPR policy, the declarant and its affiliates hereby irrevocably declares the following, and then depending upon which boxes have been checked or ticked, you can see that it is said to the extent that the IPR disclosed in the attached IPR information statement, those are the exhibits which are here. So the declarant declares that it is prepared to grant irrevocable licenses under these IPRs on terms and conditions which are in accordance with clause 6.1 of the HCIPR policy. We'll see what this clause stipulates, and that it will comply with clause 6.1 bis of the HCIPR policy. We will also have a look at this clause. And another box is ticked here, which is making this undertaking subject to reciprocity obligations. And in the attachments to this declaration, you can see which patents or patent applications have been declared essential to, well, here 5G release 15 with a work item, very specific technical specification, various technical specifications which all belong to 5G release 15 or release 16 in this example. So now let's come back to what I was telling you. I need to now share again my presentation. You can see so that the FRAND undertaking is primarily the HC IPR undertaking, but similar undertakings also exist with other standardization bodies such as the ITU, more recently Senelec, and a rather similar, although it is in some way more precise, undertaking at IEEE for Wi-Fi mostly standards. But the FRAND undertaking that has been the subject of most disputes is the one is the ETSI undertaking. Now, the first question that we should quickly see is for which patents is this undertaking, valid, or to which patent does it apply? And we have the answer in Article 6.2 of the HCIPR policy, where we can see that when someone declares a patent essential for a given standard, this declaration will apply to all the other members of the patent family. And ETSI has a specific definition of what is a patent family, which is a bit broader than the INPADOC definition, but which in a way is more understandable. That's all the members which claim the same priority date. Now, in section 6.1 bis, the HC IPR policy provides that in the event that the declared patents would be assigned, transferred to somebody else, this assignment will not affect the undertaking. In other words, the undertaking will follow the the assigned patents. This is why many experts are talking about, FRAND encumbered patents, because the undertaking is attached to the patents in question. So what we should keep in mind here is that the very purpose of a FRAND undertaking stems from competition law, from that's the whole law about essential facilities. It has little to do with intellectual property law. It is clearly intended to prevent any potential stranglehold of the market by one actor who could block the market, block all the efforts of the whole industry to adopt technical specification. And this is aimed at allowing the promotion of a widespread adoption of industry standards, while ensuring, and that's as important, that the SEP owners, i.e. The innovators, those who have invested into research and development, are fairly compensated for their patents. So that's basically the underlying principle. But as we will see, this is mostly something which stems from competition law and should not really implement principles of intellectual property law. So, what is the content of this FRAND undertaking? To which extent does it determine the terms of a FRAND license? When you look at Section 6.1 of ETSI IPR policy, you can see that the rights which will be granted are pretty much determined. It's a broad license grant. I'm reading it. It's at least the right to manufacture, the right to sell, lease, otherwise dispose, the right to repair, the right to use methods. So all those rights are those which you would typically find into a broad patent license agreement, and which enable the licensee to manufacture or have manufactured products and sell them, of course, products which implement or the licensed patents. Now, let's have a look at what it means under applicable law, because Article 6.1 and the whole IPR policy is subject to French law. I have mentioned that ETSI is an association, a not-for-profit organization incorporated in France under French law. And all the rules are subject to French law. That's Article 12. And this is something which is repeated into the FRAND undertaking. I have here reproduced an extract of the FRAND undertaking, which says that the construction, validity, and performance of this IPR information statement and licensing declaration shall be governed by the laws of France. Under the laws of France, it is clear that this stipulation is a binding obligation. It is called a stipulation pour autrui, or a stipulation for the benefit of a third party. And that's Article 1205 of the Civil Code, which says that a stipulation is a convention by which it is agreed between the parties that a third party who is not the signatory will benefit from the advantages of the contract. And you have many examples of that sort of contracts, especially in insurance matters, but also in license agreements. And the following article, Article 1206, says that a stipulation pour autrui is a legally enforceable contract. So under French law, this undertaking has binding consequences. It is not a mere declaration. And we will see that it has been construed in different manners by courts around the world. And that's where things have started to become odd and difficult for market players. This is precisely because for many, many years, too many courts in the world have not drawn the proper consequences under French law of this agreement. They have not applied the law of the contract, but they have applied the law of the patent, which is a gross mistake, a big, big mistake, which has been corrected only recently. So, what have the courts around the world said about the FRAND undertaking? We've seen light in the tunnel coming from West, from the UK, from the US, countries where these matters, these litigation, have always been understood as contract matters. That was especially true in the US, where FRAND cases were always seen as an issue of, a contractual issue. And with respect to FRAND at sea FRAND undertakings, the US courts have applied French law without any difficulty. In the UK, the same was done, and we've seen an important decision in 2017 in the Unwell-Panett decision, versus Huawei. Both in the US, a notable decision was the TCL Communication Technology Holdings versus Ericsson. In both cases, the courts looked at the FRAND undertaking, found that it was subject to French law, and found that under French law, that was a stipulation pour autrui, and that as a consequence, this document, this undertaking was a legally enforceable obligation under French law. And then the judges ruled on those consequences. They found that this was an enforceable agreement, that the judge could decide the terms for which the parties were unable to agree spontaneously between them, and that's what they did. We've seen many, many comments on those decisions, but from a French lawyer point of view, they were nothing but very normal, nothing extraordinary, in fact. In Germany, the situation was and still is very different. The German courts have not ruled on the contractual nature of the FRAND undertaking. They have even dismissed the contractual approach back in 2008 with the Landgericht Mannheim deciding that the stipulation pour autrui wasn't known by German law. That was quite an odd reasoning. So their approach is strictly limited to patent enforcement. And they have understood that they should, of course, adjudicate those matters within the limits set forth by the European Court of Justice, especially in the Huawei ZTE decision of 2015. I will not comment this decision, which is well known, but which basically says that the owner of a standard essential patent is in a position, in a dominant position, and this owner would abuse his dominant position if he would assert his patent against an implementer, unless he would have offered a license to this implementer to take a license at conditions which must be precised, disclosed, detailed, And then the implementer has a duty to answer and to make a counter offer. But this decision by the European Court of Justice was made based on the basis of competition law, and the European Court of Justice has not taken into consideration any factor, anything that would stem from French contract law. So this is perfectly consistent. The Court of Justice has rendered a decision which is perfectly consistent with French law, and in fact, we reach a result which is very similar under both the EU competition law and the French contract law. However, the German courts have until now refused to admit that the FRAND undertaking is a legally enforceable contract under applicable law. This is the subject of many discussions, and from the French lawyer point of view, this is something which is beyond any logic. Now let's have a look at what the French courts have said. They have said on various occasions that the FRAND undertaking is a legally enforceable decision, a legally enforceable agreement. They've said that in a 2014 decision, LG versus Corvallis. They have said that in the same case on appeal, in both the first instance courts and the Court of Appeal have agreed in this case to adjudicate FRAND rates. They ultimately decided that none of the asserted patents were essential, reason why they would not decide a FRAND rate, but they accepted to be competent to decide FRAND rates simply because the nature of the FRAND undertaking wasn't disputable. In a decision rendered yesterday by the Paris Court of First Instance, in a case initiated by the Chinese company Xiaomi against Philips and against Etsy, the court admitted that it was competent to adjudicate it. Xiaomi is asking the court to set forth the FRAND rate of a license that is being disputed between Philips and Xiaomi. Philips wanted the court to rule that it was not competent because Philips had already asked courts in the UK, in the Netherlands, and in Spain, and also in India, I believe, to rule on infringement contentions raised by Philips against Xiaomi products. But the French court yesterday dismissed the Philips motion, and based upon the fact that none of the foreign courts were asked to decide a FRAND rate, and the court added this sentence, which I have reproduced here, which says, and it's interesting, moreover, it was foreseeable that the Philips companies would be sued in France by defendants who consider themselves to be beneficiaries of an undertaking given by those companies in the context of a tripartite agreement subject to French law entered into with a body, Etsy, having its seat in France, of which they are members and which itself subject to the jurisdiction of the French courts. What the court is saying here is this: stop bothering, going in Spain, Netherlands, Germany, UK, or wherever to discuss something which is obviously subject to French law and French courts. That's the message. So this is this decision of yesterday. Now, what are the consequences on licensors and implementers under French law? Well, as I mentioned earlier, under Article 1205, this undertaking is clearly a stipulation pour autrui, a stipulation for the benefit of third party. And like any agreement, it entails the duty of good faith. And that's a very specific agreement. If you analyze it, that would take too long today, but if you analyze it, you understand that this is clearly an agreement to negotiate. And under this agreement to negotiate, the parties agree that they will negotiate the license agreement that is contemplated by this FRAND undertaking. But they must do it in good faith. What does that mean? It means that on the licensor's side, the licensor must provide all information that is needed to reach an agreement. That's very, very compatible, and you can reach under French contract law the very same result that you would reach under the Huawei TV decision of the European Court of Justice. You have a duty of disclosure under this good faith duty. And pending the, as long as the discussions are ongoing, the licensor cannot seek an injunction. Why? Because under this agreement, clearly the implementer has a right to implement the patent. Now, of course, there are obligations binding upon the licensee as well. The licensee must also negotiate diligently and in good faith. Very much like what the Court of Justice has said. So if the parties fail to find an agreement, they can ask a judge to determine the terms of the license. They can ask the French judge or another judge, but the other judge will always have to apply French law to this agreement. So what does that mean? It means that there is no hold up, but there's also no hold out possibility if you construe properly this undertaking under applicable law. It also means that in order for those two parties to fulfill their duties, they need to do a number of things. And that's where we have developed and offered features, functionalities under the FrandAvenue platform, which help both SCP owners and SCP users to comply with their obligations. I would invite you to go on FrandAvenue. I don't want to take too much of your time, but you can see that on FrandAvenue, you can very easily first find who owns what are the portfolios of a given party. The SCP owner can present its portfolio. It can explain what are the terms of his licensing program. And remember, that's a duty under applicable law. So the licensor can fulfill his obligations by describing the terms of his licensing program. What patents are comprised into a given portfolio? What terms apply? What is the negotiation framework that this licensor contemplates as a reasonable negotiation time frame, for instance? How long should it take, according to this licensor, to first agree upon a non-disclosure agreement, for instance, or to agree upon what documents should be exchanged, and vice versa. The licensee, which also is bound by a duty to negotiate in good faith, but which also needs to be protected, can say, okay, fine, here are my terms. I don't want to spend less than this amount of time on the negotiation, because that's the reasonable amount of time I need to assess the value of a portfolio. That's also, my licensing in terms. For instance, I am an automotive company, and I want my module suppliers to be able to participate into this negotiation process, for example. Then what you can do, so you can use your public profile to put your terms. You can decide to make them public or keep them privately until the other party has agreed to exchange on a confidential basis. You are not bound to be completely to disclose everything. You can decide what you need or what you want to disclose. And once you have those very sophisticated information and loads of information, then you can analyze it. You have tools. That's our portfolio analysis dashboard. Once again, I mean, I'd be very happy to provide a live demonstration for those who would be interested. But on that tool, you can compare portfolios. You can compare portfolios using the criteria of your choice: geographical reach, aging, essentiality, technical specifications, use cases, all the filters of your choice which allow you to compare the overall, say, 5G patents for a specific technology and specific use case with licensors A, licensors B, licensors C, patent portfolios, licensing terms, and so on, so that you can usefully, efficiently compare in order to have, I would say, a civilized and more sophisticated discussion than what you would have using, exchanging a few claim charts with a prod list or a few samples of a given portfolio and being unable to have a real comparison with the rest of the world and the real world. So that's some examples of the tools that we make available to our members. Now, if you have any question, I'd be very happy to answer. You can use the chat tool. I can see one question about the subscription plans. Well, that's freely available on you can easily see that on the platform. We have free of charge subscription plans for those who want the basic information. To put a long story short, all the information that Etsy and patent offices around the world make available for free, you can get it for free on our platform. The big difference being that you have an easy access and immediate access on, all the patents that have been declared essential to standards. If you go to the Etsy website, you will see that it's very often it's quite it's not very easy to quickly go through and understand who owns what. Now, if you want to have more sophisticated features and tools, you can take subscriptions, of course, at various levels. The more you pay, the more you get, basically. Any other question? I think that's all for today. So I wanted to not to take too much of your time. I would like to thank everyone for your attention, and please stay tuned. We will have other webinars on very specific FRAND topics, and of course you can have a replay of this whole webinar available on our website. It will be posted very soon. Thank you very much to all, and have a nice evening. Goodbye.